Hello, Namaste, Adab, Sat Sri Akal, Pranam to all. How are you all? I, Sakshi Kilawat, back again with PT 365. We were discussing issues related to the Constitution, and in today's video, we'll learn about right to be forgotten. Delhi High Court has upheld right to be forgotten of an individual. Right to be forgotten is the right to have personal information removed from publicly available sources, which includes internet, search engines, databases, websites, etc. And once the personal information in question is no longer necessary or relevant. Right to be forgotten comes under the right to privacy. Presently, India lacks provision regarding RTBF in its statute in the law. Though the Personal Data Protection Bill 2019 includes it, but it lacks specific right to erasure of data. As given by the European GDPR's Article 17, outlining the circumstances under which individuals can exercise their right to be forgotten or right to erasure. Let's see what is right to be forgotten in detail. Right to be forgotten, which allows a person to seek deletion of private information from the internet. The concept has found recognition in some jurisdictions abroad, particularly the European Union, while the right is not recognized by law in India, which lacks statutory provision. Courts in recent months have hailed it to be an intrinsic part of the right to privacy. At least 8 petitions are pending before Delhi High Court seeking removal of private information from the internet, court records of previous convictions and proceedings, and news reports of past events. Only a few have been able to get that relief from courts. ये law किस country में है? Let's see. The European Union in 2018 adopted the General Data Protection Regulation Article 17 GDPR. Next, Russia in 2015 enacted a law that allows users to force a search engine to remove links to personal information on grounds of irrelevancy, inaccuracy, and violation of law. इसमें इंडिया की पोजीशन क्या है? In a brief reply in one of the petitions earlier last month, the center told the Delhi High Court that the right to privacy has been recognized as a fundamental right. In the K.S. Puttaswamy judgment 2017, ये judgment right to privacy इस judgment के अंदर right to privacy fundamental right में include किया था, and that right to be forgotten is evolving in India. अभी तक अच्छे तरीके से इवॉल्व नहीं हुआ है, वो ग्रो कर रहा है. The government said the Personal Data Protection Bill, which is a joint parliament committee's report, which was tabled on December 16, contains provision to the doctrine of the right to be forgotten. और इस पर कोर्ट्स की रूलिंग देखते हैं. In May 2019, Justice Pratibha M. Singh of Delhi High Court, dealing with the civil suit seeking removal of certain news reports on Me Too allegations against the managing director of a media house, it said the right to be forgotten and right to be left alone are inherent aspects of the right to privacy and restrained republication of the news reports. May 2019 में जस्टिस प्रतिभा एम सिंह ने of Delhi High Court ये रूलिंग दी थी that right to be forgotten and right to be left alone are inherent inherent aspects of the right to privacy. ये आर्टिकल 21 of the Constitution के अंदर आता है. In April 2021, the court directed removal of the judgment from search results. The order is now being opposed by Google. In Jan 2017, the Karnataka High Court ordered its registry to ensure that any internet search engine does not reflect a woman's name in an order passed in 2015. And in November 2020, Odisha High Court की ruling है in a case relating to videos uploaded on Facebook by a rape accused, which opined that allowing such objectionable photos and videos to remain on social media platforms without the consent of a woman is a direct affront on a woman's modesty and, more importantly, her right to privacy. It did not, however, pass an order on removal of the photo. Let's see the ongoing cases in Delhi High Court. Some of the petitioners have sought removal of orders in cases in which they have been acquitted or already served their sentences. There is also an actor's plea for removal of videos, photos and articles related to a drink driving incident. The court in August had allowed an actor's plea for removal of explicit videos from YouTube and other platforms. Lawyers for the petitioners acknowledge that in the absence of statutory backing, the relief being sought is likely to clash with the public's right to know and the functioning of online platforms such as Google and Twitter. Until and unless something is written, it always lacks a backing. I guess that's all for now. We'll meet in another video. Have a pleasant day.